I would submit to you it's clear that the question whether or not the judge has an interest in the very outcome in marrying is relevant to the issue of disqualification. But, Your Honor, Judge Reinhart, you accurately did characterize our argument. And the point I want to make here is that in filing after filing, it is the plaintiffs who have stressed the long-term nature. Here's what they say. Plaintiffs are gay and lesbian residents of California who are involved in long-term serious relationships with individuals of the same sex. Plaintiffs Perry and Steyer are lesbian individuals who have been in a committed relationship for 10 years. Plaintiffs Katami and Zarillo are gay individuals who have been in a committed relationship for 8 years. One filing after another makes the common sense point, not difficult to grasp for anybody, that a person in an enduring committed relationship raises the obvious question, do you have an interest in getting married? And it was the plaintiffs who introduced evidence that in the state of California, 64% of all committed gay relationships would ultimately seek to get married, 64%. That wasn't our evidence, it was their evidence. And it was based upon the committed, long-term nature of the relationships at stake. Judge Reinhart, you are correct. These are things that raise the issue. I am glad that counsel for San Francisco and the plaintiffs have raised the Alabama case. Because in that case, Judge Hawkins, the court emphasized this, the 11th Circuit. There is no evidence that Judge Clemens' children have any desire or inclination to attend a Montgomery area institution. The institution's at issue there in that higher education desegregation case. Judge Clemens had made clear, he acknowledged his obligation to disclose personal facts. And he said, I have no evidence that my kids want to go to these institutions. Is it the plaintiff's position that if Judge Clemens had come back and said, my son has an application pending at those Montgomery institutions, that would have made no difference? That he could have sat on that case? That is an appalling proposition. And it would bring the federal judiciary and its integrity low, Your Honors. And there is no case anywhere in American jurisprudence that says a judge that is a minority, because he is a minority, he can sit on his own case. There would be no problem, that we are aware of anyway, for Judge Walker to have sat on Don't Ask, Don't Tell. Even though he's gay, even though he's a minority. Because as far as we know, he would have no interest in the outcome of the case. But if Judge Walker was ruling that he has a constitutional right to get married to his 10-year-long partner, as soon as his ruling is affirmed, if it is by this court, then if this court does not says what they urge you to say, that that's just fine, this will be a signal and dark day in American jurisprudence.